Good morning. Welcome to Tips and Tricks for Enforcement of Family Law Judgments and Orders. I am Ryan Wedeking, co-chair of Beverly Hills Bar Association's Family Law Section. The Family Law Section is sponsored by White Zuckerman, Lawyers Mutual Insurance Company, SoberLink, and Our Family Wizard. White Zuckerman provides a variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Learn more at wzwlh.com. SoberLink provides objective, real-time data that can be used to reduce disputes over alcohol consumption, leading to less conflict in custody cases. To help ensure smoother negotiations for a more efficient legal process, consider using SoberLink's trusted alcohol monitoring system to eliminate hearsay and protect your client's best interest. With an unprecedented combination of features, including advanced reporting, facial recognition, tamper resistance, real-time results, and customized testing, the discrete system has been the leader in remote alcohol monitoring since 2011. Learn more at soberlink.com. Lawyers Mutual. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance. Their experience and expertise are complemented by the fact that LMIC is directed by a group of dedicated lawyers. They offer special rates with competitive premiums for a wide range of areas of practice, including family law. Learn more at lawyersmutual.com. Last but not least, Our Family Wizard is a co-parenting platform designed to help families communicate more effectively, reduce conflict, and create reliable court-admissible records. Features like tone meter, shared calendars, expense tracking, and in-app audio and video calling help support compliance and better outcomes for families navigating custody matters. Now, I would be remiss if I did not mention our family law section meetings, which are the third Wednesday of each month. Please join us for those. We often are joined by the presiding judge of the family law bench downtown, Judge Kaufman, and among other judges. So it's kind of like a mini state of Department 2 each month. So to kind of be up on the state of the art and to participate in the family law community fully, we invite you to attend our meetings each third Wednesday of the month. Now, I am delighted to introduce our speaker today, Ira Friedman. Ira really needs no introduction. He's a certified family law specialist and partner at Friedman Friedman with over 50 years of experience serving Los Angeles, Ventura, and Orange counties. He was the prevailing attorney in 2 cases that you well know, marriage of Gavron and marriage of Keach, addressing spousal support termination in long-term marriages and attorney fee order requirements, respectively, in addition to comprehensive family law practice encompassing divorce, child custody, support, and marital agreements. He's developed a recognized subspecialty in enforcing orders and judgments referred by other family law attorneys. Mr. Friedman is a fellow of both the American and International Academies of Matrimonial Lawyers. I believe that's the AML and IAFL. Has served in leadership roles with the Los Angeles County Bar and the Beverly Hills Bar, and has been a judge pro tem and family law mediator for Los Angeles Superior Court since 1980, before I was born. Now, Ira, let's get started.
Okay, thank you, Ryan. I appreciate that. I think you must have been talking about somebody else other than me, but be that as it may. First of all, to get you all to stick around to the end and not just turn it off beforehand, I'm going to tell you how you can sometimes take simple interest and turn it into compound interest. And we'll get to that toward the end. The seminar is not a seminar where we're going to go through all the different methods of enforcing a judgment. This is the tips and tricks in enforcing judgment. And most of this has come from trial and error on our part here, where we've tried a few things. We didn't know whether they would work or not. And surprisingly, they did. We've had others that we thought would work, didn't work. But these are extremely practical tips I'm not sure we even cited any cases because this is a true meat and potatoes presentation. So let's go to the next slide, please. I don't know how somebody's supposed to move this along here. There, that's it. Thank you. First of all, the best source of information is usually hiding in plain sight. If you go through the underlying files in the dissolution from the other side, that they've supplied you, as an example, when somebody is not paying support, and if you check the PDDs or the FDDs for information, this may be better than kicking the can down the road and hiring a private investigator. In most cases, the investigators are going to give you information you already find online. Also, Westlaw and Lexis have a component that we have here. We use Lexis. It's not better or than Westlaw, but has personal information. And sometimes, not always, you can come up with information that way that'll help you. Next slide, please. If you don't know where the debt or banks, we tried this some time ago in a case where we had a judgment, but we did not know where they banked. So we sent the sheriff to the Big Five, and unlike real estate, there's no central depository of information as to where you can find information about banks. So as this slide will show you, these are the Big Five. And in the case we tried it with, we had a judgment, and the debtor was a real estate agent who is a contract worker, so no taxes are taken out. She had money set aside to pay taxes based on her commissions, and we sent out to these 5 banks, and we found all of the money she had there. So this has been something we've tried, and it's been very successful because of the fact that most people have an account at one of these banks. The other thing you can think about is in the case of another bank, where is the debtor's business if they have a business? And it may be likely that they have an account in the same building if there's a bank downstairs. That's another way. And we've also found that trying to find out banks with a private investigator is a hit and miss. I don't know where they're getting the information, but it's extremely difficult to get information about bank accounts. And by the way, you really need the Social Security number, not the account number. In fact, if you have the account number, it's useless because all of the banks keep the records by Social Security number. I apologize, I have a terrible post-nasal drip, so I'm continually clearing my throat. Can we go to the next slide, please? So the sheriff has 2 speeds, slow and slower. However, instead of having the sheriff serve the writ of execution, you can use a registered process server to serve on the bank. Check with your attorney service as to the cost of serving the bank. Our regular attorney service is considerably more expensive than the attorney service we use for bank levies. And this is an unsolicited promo. We've been using Zach's attorney service. She's in Valencia. Zach happens to be her son's name. And it turns out that it's been much more effective. And the other thing is you can't predict when the sheriff is going to serve the bank. And it may be you have knowledge that on, let's say, June 12th, 2026, there's going to be a considerable deposit, you don't have the luxury of having the sheriff make sure they serve it like let's say today. With a private process server, you can have that, make sure they serve it on a certain day, because a writ of execution is only good, in other words, the date the bank gets served, not the day after. So if they serve it today and then tomorrow is when the deposit hits, you don't get that money. You only get the money that was in the account on the date it was served. In the past, we've done this on February 13th. You say, why February 13th? Because it's a day before Valentine's Day, and that's usually a big day for florists. And there also may be other days, depending on the type of business, that you want to get it served if possible. So that's another tip that we've used in the past and which we continue to use. Next slide, please. Okay, now when you levy on a stockbroker, most of the stockbrokers will tell you, yeah, we'll give you the cash, but we're not going to give you securities because there may be a difference in the cost basis. And if we sell XYZ stock to satisfy the writ of execution, the problem is XYZ stock may have a very low basis. And when it gets sold, the debtor is going to have a significant amount of tax liability for that, because the IRS, whether you levy on it or not, considers that a sale, and they will have to report in effect here, a phantom profit, even though they didn't get the money. So the stockbroker will take the position, you're going to need a sell order, and from the court, the sell order is issued by the court. And what we do is we ask, so there's no ambiguity, just sell it in alphabetical order, because we don't know usually what is in the portfolio. Let's say on June 12th, we don't know whether there's 2 stocks, 3 stocks. I mean, we may not even know what the nature of the stocks are. So this way, when the court issues that order, the sell order, the broker will sell it in alphabetical order. This has come up a number of times, so you may want to try, and I say try, I don't know whether you'd be successful in getting the sell order on an ex parte basis. It seems that anything concerning money, the courts don't seem to think that that's a significant emergency. And they'll just put it on the regular calendar. And the problem with that is the other party is going to know about it by that time. So you can try. I don't know how successful you'll be. The next slide, please. Quadro for support. A lot of people are not even aware of it. When you say quadro, they say, you know, I'm going to have to retain another lawyer who specializes in quadros. Actually, you don't need somebody. It's a judicial counsel form, which a lot of lawyers are not aware of. It's FC, it's actually FL 460. As the name implies, it can only be used for child and spousal support. And you can only use it where there's a pot of money. So in other words, if it's a pension plan that has a defined benefit, you're not going to be able to do anything unless the debtor is receiving payments now. If there's a defined contribution plan, there is a pot of money there. And we've used this to get all of the arrearages in one time. So you have to kind of find out ahead of time. And you can, a lot of the information you can find online. As an example, if you were trying to get money from an actor and you went to SAG-AFTRA, SAG-AFTRA only has a defined benefit plan. So unless the debtor is actually receiving benefits, you're not going to be able to get anything. However, the other the union that represents the people behind the camera, the Motion Picture Industry Fund, has both a defined benefit and a defined contribution. So you can use it there. And you can also get it out of an IRA or a Roth 401 and a Roth or a 401k. However, those maybe the 401k is easier, but the IRA, they may be able to get an exemption. And it would be up to the court. It would be up to them to file for the exemption. But again, you can't, a lot of times people say, well, can I stick my attorney's fees that are unpaid in there? You can't unless the court order or judgment says they are awarding you X dollars in attorney fees in the nature of support. In that case, you could, but it's only for support. And you can include the arrearages in the quadro for support, and you could also include the ongoing amount for support. There's different parts to the form. And the form is pretty straightforward to fill out. We had one now where the debtor retired, a long-time employee, but he has a retirement plan with the employer. So we'll just switch over the amount that's still unpaid. This is hardly ever used by people. And we found that it's a great way to start to get money in cases where you can't find anything else that the debtor has. And here's the information you're going to need. The plan administrator is what you really need to find out. A lot of this is available online. So if you find out that the person works for the county of Los Angeles, you can look up the plan for, I think it's Lacera for the county of Los Angeles, and all the major employers. You usually can find out who the administrator is, because that's who you're going to have to serve the quadro for support once the court issues it. There you go. Okay. Can we go to the next slide? Okay. Residuals and royalties. The royalties are with music. There's 3 different agencies that actually keep track and pay the money out. You'll see how this differs from residuals. Royalties, either ASCAP, BMI, or Sound Exchange pay out the money. And the way you can find out is where the person who receives royalties, which one they use. Usually they'll either use one of the 3. So once you find that out and you get an order assigning to your client the royalties, then ASCAP or BMI or Sound Exchange will start to pay your client the money. Every 3 months is when they pay the money out. So you can usually find out online about whoever the musician is. However, in some cases, believe it or not, engineers are getting royalties, and they usually use Sound Exchange, which is actually not local, but still, once you find out and you file a motion for an assignment order saying that your client is owed X dollars and the person is receiving royalties for music from ASCAP, BMI, or Sound Exchange, and you serve one of those three with the order, then every 3 months, and they're also 3 months behind. Like June is going to be coming to an end. They're going to just be paying out first quarter royalties. And the thing about royalties is you can't, the client will say, well, am I going to get all my money now? Well, it's doubtful because there's no way to predict in any given quarter what's going to generate in terms of royalties. If the musicians go on the road, even though putting aside whether you could get money from live performance, which I'll get to in a minute, it turns out that that stimulates the amount of royalties they can get by whether it's streaming or whether they're selling DVDs or whatever. So it's another good way to get money, and it's very uneven. You may get very few dollars this month. Next quarter, you may get more. So whatever it is, it is. As far as trying to, is a side note, trying to get money because they're performing live. The problem is you have to find out who the actual promoter is that's going to be paying them. And usually by the time you find out, they're gone to the next menu and they've been paid. So that doesn't usually work out. In the terms of actors, as it indicates on the slide, it's a two-step process. First, you're going to have to file a motion to set a deposition for the custodian of records for SAG-AFTRA. What you'll get is this printout that in some cases goes on and on and on, but because it lists every project, whether it's a movie or a TV show, and you'll see things like 10 cents, 20 cents, whatever it is, but you'll get an idea where they're getting most of their residuals from. And once you get that, then you can have the assignment order, and you'll ask in the proposed order for the following items, namely the following places: Columbia, Sony Studios, whatever. And then once you get that order and serve it on the entity, you'll get paid the money. SAG-AFTRA does not have money. A lot of people think they're the ones who pay out the residuals. All they do is keep track of the residuals. They don't pay anything out. So again, it works so like the royalties, where sometimes there's no money, and it as the slide indicates, it's sort of a reverse geometric progression. So if the debtor received $1, next time 50 cents, then a quarter. But a lot of times there's a bump if it's syndicated. As an example, Seinfeld, which is probably one of the most successful syndicated shows, and it's syndicated in individual markets. So if it's syndicated, let's say in Seattle, Washington area, there's going to be a bump for that area. It's a one-time bump. Let's say it's Kansas, whatever area, there'll be bumps because it's an individually negotiated contract for what a certain geographic area. The music royalties is, I think I talked about that too. Yeah. And as far as royalties, could you go back one there? As far as royalties, the interesting thing is that there are two types of the royalties. There's the composer royalty and there's the publisher royalty. They can be the same person, they can be separate. And also you'll notice in the press in the last couple of years, you'll see articles where a certain musician has sold their catalog to a certain company. And that then becomes the owner of whatever royalties that musician had at the time. And it's a crapshoot for these companies because it may turn out that it doesn't generate any royalties and they've paid all this money. So it may be that instead of ASCAP, BMI, or Sound Exchange, you would end up serving on the third party now, unless the musician kept a portion. If not, then there may be nothing to go after at that point. Although it may be that they only sold their catalog up to a certain point. It's hard to tell when they do this. So that's something to take into account. But we have found that that's a successful way to get money. Uh, okay, let's go to the next. Next. Uh, if the person is working in a TV series still in production, you can serve the employer in earnings withholding or support or other. That's not limited to that. You could do for the attorney's fees. It's you have to find out who the actual employer is. You may see that the TV show was produced by Apple, or it was produced by Warner Brothers. But you come to find out that actually the actual legal employer was Entertainment Partners, which is a payroll company that pays actors, because in some cases a studio may give them the lump sum of money to pay all the employees, and they dole it out, and they are technically the employer, and that's who the employee, the debtor, will get a W-2 from. And again, remember, for support, you can get 50% of net, and for non-support, namely attorney's fees or equalization, you can only get 25% of the net. So a lot of times people want to sell a car, boat or plane. I don't know how many boats or planes come up, or anything else like that. But first of all, if the car is leased, you can't do it because the car belongs to the leasing company and not the debtor. And if it's financed, you need to make sure there's enough equity, because the sheriff requires around 2,000. There's also an exemption of 1,800, so you may not be able to sell it. Very rarely is a car worthwhile to sell unless there's a lot of equity, and it also sometimes is an impetus for the debtor to pay everything, even though you may not get all the money out of the car, because people are not happy about losing their car. And the same with a boat or plane. Also, if there are other items other than this, like valuable art, not like art that I have, not not worth much, but rarely you'll see this, but some people do have very valuable art. So the tip is you're going to have to find out from the sheriff what the deposit is, because the sheriff isn't exactly it's not the one who comes out and tows the car. They have a contract with a vendor, and they also have contract with other vendors. So they will probably have to get back to you. As an example, if you say, well, the debtor owns the Mona Lisa and other valuable paintings, they will have to find out from whoever they have a contract with what the deposit is going to be, because in that case, the deposit the sheriff is going to require is going to include the fee for the sheriff and an additional amount of money to be kept by the sheriff for insurance and storage until it can be sold. And those situations are sort of one-offs, because very rarely do people have things like that they want to sell, namely car, boat, or plane. The boat, we've sold a boat once, but it's also very rare, and it wasn't a big thing. So you need to first of all find out the deposit to see if it's going to be cost effective. And the other thing is you need a private place order. Next slide, please. Here's what a private place order is. If the car is in a garage, whether it's at the debtor's home or a private place, and the sheriff goes there and they won't let the sheriff open the garage, the sheriff comes back and just says, we can't do anything. So what you need what's called a private place order. A private place order gives the sheriff the authority to, as an example, to go into the garage. And if they won't open the garage, basically the sheriff will say, wrong answer. You either open it or will open it, and they'll do whatever's necessary. So the problem is if you go out once without a private place order, as an example, to pick up the car, you'll find out that the next time when you do get the private place order, it's going to be too late. So if you pretty sure that the vehicle in this case I'm giving you is going to be in a garage, you need to get the private place order before you have the sheriff go out there the first time. And the sheriff, the court will issue the order. However, a lot of times it took convincing to issue the order on ex parte basis without giving notice, because if you give notice, the car will be somewhere else. The private place order also works with, as an example, a safe. If you have a business that has cash lying around, the sheriff, if they have that order, they'll bring a locksmith to open the safe. So it has a lot of uses, but you're going to have to get the order beforehand, or the safe won't even be there next time. So that's another tip that we've used before in coming up with a way to get money. In fact, we had it as safe at a 7-Eleven that all the judge, after that we went back for fees, and the judge, rest in peace, Judge Black, all he said is, Mr. Friedman wouldn't be standing here asking for fees if your client paid, would he? So let's go. And the sheriff doesn't extend credit. Abstract of support. Here's where we actually cited a case. Make sure you record the right one for whatever kind of debt. In other words, if it's support, it's going to be an abstract of support judgment. If it's for other than support, it's just going to be an abstract of judgment. And because there's boxes, it's very easy to just check off unknown, date of birth, last 4 digits of the social security number. The case, Keel versus Reach, 1985 case, it may invalidate your lien. And I've had that happen where we took over a case. They recorded an abstract, but they just checked off it was unknown. And the fact of the matter was, they had the information because they had the tax returns of the party who owed the money. So be sure and get the information if you have it. If you honestly do not have it, have no access to it, then you can check it. The other, next slide, please. No, back one. Yeah. If you want to record in another state, you need to check with the county recorder in whatever county is. Some states will require you to domesticate the California judgment in the other state before you can either record the abstract or abstracted judgments. Other states will record a California abstract in another state. You need to check with the particular county recorder because it may be different counties have different rules. So that's important to check. There's another thing about abstracts that you need to know. A lot of people figure, well, I've got an abstract, so if they sell the property, I'm going to get paid. Well, there's something called equitable subrogation. You're going to like this one. Equitable subrogation is where, let's say, the Bank of America issued a mortgage, a trust deed for $100,000, and then they're first in line. You now record your abstract or abstract of support judgment. And now Wells Fargo comes along and they refinance the $100,000. And you're saying, well, wait a minute, where's my money? Well, equitable subrogation, and there are cases, it's not cited here, but there are cases that say that it's a valid idea, not idea, but it's valid that the second lender, Wells Fargo, in the example I'm giving you, steps into the shoes of the Bank of America and they don't have to pay you off. The only thing that changes if the second lender goes in for $150,000, then there would be a basis to collect money. But if they just replace lender number one with the same amount, you're out of luck. So that doesn't come up that often, but it can come up. And you want to make sure that once you find out that there's an imminent sale, and sometimes this becomes a problem because of the fact that, again, there's no central repository of escrows. But if you find out, even though the abstract is recorded, you know what? Even title companies miss things. So if you know it, put the title company and or the escrow company on notice saying, here's a copy of the abstract that was recorded with the LA County Recorder's Office on such and such date at such and such time. Because there may be instances where it's going to go through without it. And you say, well, they're going to be liable. Yeah. I don't know if any of you have decided that they want to sue the title company, but they just don't write checks that fast. So even though at the end you may prevail, you may be jumping through a lot of hoops. Social Security. Next slide, please. Thank you. Thank you. Social Security, a lot of people don't think you can levy on it. Boy, they surprised when they have half of their benefits taken. But they have to be receiving monthly benefits. Once you get the appropriate form for just spouse or child support, if there are arrearages, some will sign the wage assignment, including arrearages, by just sending it in to be signed by the court. Other courts will require RFO to be filed to set a sum certain for arrearages. So it depends. If you're asking for just current monthly, you don't need to go to court. And the judge will normally sign the form very fast, a very fast turnaround. But some courts, it varies, not just in county, but it varies from court to court within the court system. We've had some judges who just a day or two later sign it, others who just reject, need to file an RFO. So I can't tell you which ones will and which ones won't. So once you get that and you serve it on Social Security, the problem is getting it into their system. They don't get many of these, so you may spend a lot of time just following up with Social Security to get it into their system. Once it happens, then 50% will be paid every month to your client. And even better, when the benefits go up, your client will get more money, and they also could get the money. In some cases, we've had the money being paid to our client electronically, so we don't even see it. Other than that, if the money comes in today, we send out their portion or all of it, depending on what our arrangement is with the client. And it, the thing is, if you have to see if this is going to be cost effective, because if somebody owes a significant amount of arrearage, the question comes up: is it worthwhile to get half of 15 of $2,000, forever? And I can't answer that, but it may be better than nothing, because some of the people who are expecting the benefits and not getting anything over $1 is helpful to them. Um, Receivers, next slide, please. Receivers are considered, I consider it the death penalty of enforcement, because the cost involved, the fact that you usually have to show that you have tried and failed at various other procedures, which you should put in your declaration. In other words, I tried to levy on a bank account. I got $12. I tried to sell personal items. I couldn't do that without a LOI. That's going to be important to put in the declaration. And you also need to work with the potential receiver as to the requested orders. If you have somebody that you've used in the past and you're satisfied, you can usually call them and say, look, this is a widget manufacturing business, and they will send you specific items that they would want in the potential in the order for the appointment that are specific to the widget business, as an example, and they will help you even though they haven't been retained, because all they're going to do is look over that, and they will also provide you with a declaration recounting the fact that they've been the receiver and how many matters and in the such and such field and so on. And that's very helpful. As far as one of the things that I have asked the receivers to put in is where you have a professional corporation, and the professional corporation also needs a provision in there that, as an example, let's assume the debtor is a doctor, a lawyer, an accountant, and there's a professional corporation. You may want to put in there that the debtor turns over all of the stock he owns in the XYZ professional corporation and endorses them to the receiver, period. And in the event that the debtor does not turn over the certificates and endorse them, then the receiver is authorized to issue new stock certificates in the receiver's name. The odds are, if the debtor is ordered to turn over the stock in his professional corporation, he's going to say they're missing, he can't find them, and so on. So we've done that, and there are some issues as to whether it's valid, because basically what you're doing is you're asserting jurisdiction over a non-party without the benefit of having an order joining that party. But in some cases, the judge may be totally fed up with the debtor anyway, and they would grant that kind of an order. It's the old story. If you can't ask, you don't ask, you can't get. Next slide. Yeah, Okay, so and I've had receivers get that kind of an order. You've now asserted jurisdiction over this third party without the benefit of having to file a motion and all that, which may slow you down. And it's especially helpful when you have a debtor who runs everything through their, in fact, they may not even have a personal bank account. Everything is through their professional corporation. Laundry, whatever they go out to dinner, everything is on them. And so there is no personal account. So why don't we go to the next slide? A lot of people think there's no post-judgment discovery. This is another thing that people are unaware of, is specific code sections dealing with post-judgment production of documents and interrogatories. That 708 should be 020 for the interrogatories. And if they have an attorney, they'll respond. If they're pro per, all you're going to do is add to the by filing a motion to compel. You probably end up just spending more money. So instead of owing X, they'll now add X plus Y for the motion. So that's another area where you can collect money. I mean, which you can. We've been using that lately. Now, that's the last slide. However, I'm going to tell you a way you can take simple interest and in effect turn it into compound interest. Family law judgments never expire as opposed to civil judgments, which have a 10-year shelf life unless they're renewed. If you take a look at CCP 683.110 et sec, you'll see that if you renew the judgment, like let's say in this example, the judgment was for $100,000 and 5 years later, it's now $100,050 and $50,000 because of the interest. So now you have $100,050. When you renew it, you roll into the renewal amount the outstanding attorney's fees. So when the judgment is renewed, it's for the total amount, including the previous order for attorney's fees, which now is included in the principal. So after, let's say, the 5 years, you renew it, then it's collecting interest on the interest. So that's a quick way of doing it. And you can continue to renew family law judgments. The question is there enough money that is accrued for interest to make it worthwhile? So you have to decide on a case-by-case basis as to whether it's worthwhile to renew the judgment. There was a time when people thought you could only collect for 10 years. And then there was a case that came down and said family law judgments never have to be renewed. They're valid until paid in full. So with that, if there are any questions, the person from the Beverly Hills Bar will let me know and we can see if we can help you out here.
Yeah, so Ira, it looks like we have about 4 questions so far. We have one question from Jackie. I thought only the sheriff could serve a writ of execution. Do we have the option of using a private registered process server serving a writ of execution?
It depends. You mean a writ of execution, if you're going to serve it on a bank or a financial or a stockbroker, you can use a registered process server. As I said, it's a free promotion for her. I have been using Zach, Z-A-C-H, and that's not our regular process server. I think she's in Valencia or somewhere up in northern LA County. And we've been using her because our regular process server wanted a lot more money. Yeah, and that's what we've been using to do it. Yes.
We have another one from Ashlyn. What is the judicial counsel form to file for a private place order?
Oh, there is no judicial counsel form. It's just a request for order, an RFO you have to file. You'd ask the court for a private place order.
All right, looks like we have another one. What notice to the opposing party is required for a quadro orders, private place order, and the like?
Well, I've tried ex parte for a private place order. I've been successful sometimes, and sometimes the judge says, no, I think they received notice. And I said, they received notice. The car's not going to be there. So that's been a problem. What was the other part of the question? I would try ex parte. The worst that can happen is you don't get it. But you have to stress the point that the reason you need it on ex parte basis without notice is that car is not going to be in that garage. What was the other part of that same question?
Yeah, what notice to the opposing party is required for quadro orders, private place order, and the like?
The quadro for support, I think you have to give notice because that's going to be an RFO on a regular calendar basis. I can't even think that anybody would order it on an ex parte basis.
All right, I have another question. What is the proper way or percentage to determine amount of payment on arrears when it is substantial?
Can you repeat the question? I'm not sure I understand the question.
Yes. What is proper way or percentage to determine amount of payment on arrears when it is substantial?
Well, first of all, what we do is we use either ex-spouse has it or the old CFLR executioner, which you input, and they both work the same way. You input, as an example, the monthly payments, and then you input the payments that are due, and then you input what payments are made. It will allocate the money according to the code between principal and interest. Aside from that, and it'll also, if there's lump sums due on a specific date, it will incorporate that in. Those programs have been very useful to us in applying for the writ, or when the court says, I need to know how much is owed as of today. Because once you save it in those two programs, you could just crank it out. We have a case now where we know how much was owed. He retired, but there's still some money coming in. So as soon as that last check comes in, we can insert it and it'll come up with the new amount that's owed. I think I've answered the question.
Alrighty, and then I have another question. Can you attach Social Security for regular non-family law judgments?
Nope. Only for support.
All right, I have another question here. Let's see. Your last slide says you can add attorney's fees if the debtor does not respond to discovery. Is that per the Code of Civil Procedure? What section of the statute authorizes attorney's fees?
Well, you mean as far as post-judgment, where they don't respond to the discovery? If that's it would be in the same section. I think it would be like somewhere in the discovery portion of the Code of Civil Procedure, where you would ask for attorney's fees for not responding to discovery. I don't have at the top of my tongue the code section, but it's the same code sections for non-production of documents or interrogatories, even though you're sending them out under a different section.
All right, it looks like we have a couple more now. If there is no receiver, how can you collect from an LLC?
Well, you'd have to you'd probably have to file a motion for joinder of the LLC. Or if not a joinder, the other thing you could do is you could file for an assignment order and a charging order. And then if it was granted, the LLC would have to pay your client rather than the debtor. You'd file both at the same time for a charging order and an assignment order. And then when it's served, then the money would go to your client. As an example, let's assume that the debtor is with an accounting firm or a law firm that's an LLC, and you get the assignment order, then the money would go to your client until it's paid.
Let's see. How will you know if the debtor has stocks if the broker only sends cash in the brokerage account?
Only does what?
How will you know if a debtor has stocks if the broker only sends cash in the brokerage account?
Well, you may not know. I mean, if you were involved in the underlying dissolution, you would probably know that they have an account at the XYZ brokerage house, but you wouldn't know what's in that account. So, you know, it's a shot in the dark whether you'll find out that they may only have cash, but the odds are that they wouldn't just keep cash there because they would want to improve their return on investment. So they may have mutual funds with the broker or they may have stock. In either case, that's the reason they would have an account there.
Okay. And let's see. If you have two orders for attorney's fees, can you consolidate the two and renew them together, or does it have to be separate? What is the renewal procedure?
You could renew both of them at the same time in one renewal.
Okay, it looks like we have a clarification from Susan, who had asked the question about arrears. To clarify of the amount to include for arrears, I'm referencing on a waste assignment.
Wage assignment. Well, I don't understand what the question is then.
I do have another one here from Donald. Can you explain the procedure of collection in another state?
You're going to have to domesticate. You mean you want to enforce a California judgment in another state? If that's the question, you're going to have to domesticate the California judgment in the other state before you can collect, and whatever the rules and laws are in the other state apply. However, let me just tell you that as an example, let's say they have a Bank of America account in Kansas. It doesn't matter. You can serve them here because they're a national company and they have an agent authorized to accept service. So that's not going to be an impediment to collecting, even though it's in another state. If it's something like they have a bank that does not do business in California, then you would have to domesticate the California judgment. And every state has the different kinds of exemptions and rules. And I got enough trouble with California without trying to figure out what other states' laws are. And the same with you, if you tried to sell real estate or something in another state, it may be different. And by the way, selling real estate now is a lot more difficult because it used to be the homestead exemption ranged anywhere from 50 to 150,000. Now it is the average sale price for a home in the county that you're trying to levy on. The average number that comes up most of the time is like $635,000. It's making it very difficult because the 635 exemption, whatever it's plus or minus that, then any trust deeds that are outstanding, it makes it very difficult to find a house that you can sell. However, if it's raw land or industrial or commercial, there is no homestead exemption. There's no homestead exemption if they don't live there either.
All right, and it looks like, let's see. This is a question regarding the brokerage from earlier. How do you know if the broker doesn't tell you? Should you get a sell order first before sending in the writ to the stockbroker?
Yeah. Well, first of all, yeah, I would get a sell order first. I have no idea what's in a person's account.
Right, and it looks like we have one last question here. If you have the bank account number for the debtor, but not the social security number, how do you suggest proceeding? Is there anything to force the deposition of the bank or written discovery?
You may be able, if you have the account number, you may be able to do it that way, but most of the time they just want the account number. The interesting thing is we provide the social security number to the sheriff. Somehow when they send it to the bank or serve the bank, it's missing. And you'll get a call from the bank saying, what is the social security number? Sort of frustrating because you've already provided that. But you can try it if you have the account number. We've just always gone on the basis of that. And if not, then I guess you'd have to do some discovery, but it's gonna be I don't know how you can handle that.
Alrighty. It looks like we actually just got one last submission. For how many years are banks required to keep records?
They say they only keep them for like 6 years. However, we found sometimes when we subpoena, they all of a sudden they have them, especially since now they don't have boxes of physical records. So I don't know what the problem is. And sometimes you may have to press yourself to get it. I know as far as the person who has the account, they'll only say we have 6 years of records, but they're all electronic now. So we've had records that went back a considerable amount of time in cases, but I think it's 6 years they keep them. By the way,
Alrighty.
if anybody else has questions that they think of, you can reach me at IMF, like International Monetary Fund, happens to be my initials, at f-f-law.com. I'll be glad to answer questions. I've never had anybody abuse that, and I'd be happy to do it.
Alrighty, that looks like that's it for questions today. Ira, do you have any other closing remarks you'd like to make?
No, I enjoy doing this. This is in the end of June. It'll be my 51st year practicing, and I keep doing it until I get it right, I guess. I have no plans to retire. And unfortunately, there is no other Friedman and Friedman and Friedman anymore since one, my wife retired. She's still my wife. And my son, David, is now a Superior Court Commissioner downtown. So it's the only Friedman left.
Well, this concludes today's presentation. Thank you so much, Ira, for a fantastic presentation today. And thank you so much to our audience members for joining us. Have a lovely day, everyone.
Okay, thank you.